Today, we're diving deep into a piece of legislation that was really much more than just a new law. Think of it as a crucial system update for the UK's entire approach to invention and intellectual property, the Patents Act 2004. This was a really pivotal moment, a major upgrade that modernized how innovation gets protected, and we're going to break down exactly what changed and why it still matters today.
So you have to remember, this act was designed to be a complete overhaul of the original rulebook, the Patents Act of 1977. I mean, think about it. In the 27 years between those two acts, the world had changed completely. The technology, the way business was done internationally, the legal treaties, everything had shifted. So the 2004 Act was absolutely necessary to make sure UK patent law wasn't stuck in the past, that it was still relevant and strong enough for a globalized world.
All right, here's how we're going to tackle this. First, we'll look at the big push to get in sync with Europe. Then, we'll get into how the Act clarified the rules for some really sensitive areas of invention. After that, we'll explore how it changed the game for patent disputes, check out the practical changes that made the whole system easier to use, and finally, we'll wrap up by looking at the Act's lasting legacy.
Okay, first up, one of the biggest reasons the 2004 Act even exists, getting UK patent law harmonized with the European Patent Convention, or the EPC. You see, for inventors and businesses in the UK who are operating across Europe, having these little differences between UK law and the EPC created a lot of confusion and headaches. This act was a deliberate move to smooth out those wrinkles and create a much more seamless patent system.
And what's so powerful here is just how direct this language is. This exact quote was inserted into UK law by Sections 2 and 75, which deal with changing a patent after it's been granted. This wasn't just a suggestion. It created a legally binding duty for UK courts and the comptroller, that's the head of the UK Intellectual Property Office, to actively consider EPC principles. It was a clear command. We need cross-border consistency.
So this alignment happened on a few different fronts. As we just saw, Section 2 brought the UK's amendment process in line with the EPC. Then, Section 3 added a really important new option. UK courts could now offer relief for European patent that was only partially valid, as long as the claims were officially limited by the European Patent Office. And finally, Schedule 1 did some essential legislative housekeeping by officially getting rid of references to the old Community Patent Convention, a treaty that never actually came into force. So it was part strategic alignment, part practical cleanup.
Now, while getting aligned with Europe was a huge deal, the Act also turned its attention inward to tackle some of the most complicated and, frankly, ethically tricky areas of patent law right here at home. This meant bringing some much-needed clarity to the worlds of medicine and national security.
This is such an important and subtle change introduced by the new Section 4A. So Step 1 is crystal clear. You cannot patent the action of doing surgery or diagnosing a disease. This is all about protecting doctors and surgeons. But, and this is key, Step 2 says you can patent a new drug or a compound that is for use in a treatment. And then Step 3 takes it even further, creating something called second medical use. This means if you discover that a well-known drug, let's say aspirin, has a totally new specific medical use, like preventing a certain type of heart disease, that new use itself can be patented. It's a really brilliant way to balance protecting medical practice while still giving companies a huge incentive to do pharmaceutical research.
The Act also tightened the government's grip on technology that could be sensitive. Section 7 fine-tuned the rules, making it mandatory for UK residents to get written permission before they even try to file a patent overseas if their invention touches on military tech, national security, or public safety. This was a really critical tool for controlling how sensitive technical know-how spreads around the world.
And right here is the crucial legal upgrade within Section 7. A new subsection 3A raised the bar for what prosecutors had to prove. It was no longer enough that you just broke the rule. They now had to prove you had a guilty mind, what lawyers call mens rea. They had to show that you either knew you were breaking the rule or you were just plain reckless about whether you were or not. It's a really important change that protects inventors who might make an honest mistake and focuses the law on people who are being deliberately non-compliant.
Okay, the 2004 Act also did a lot to rebalance the power dynamics in patent disputes. It really took a hard look at the relationships between inventors and their employers, between people who co-own a patent, and between parties in a legal fight, and it introduced new tools to try and make things fairer.
So let's quickly run through these new powers. First, Section 6 gave more muscle to people in ownership disputes, making sure they still had options even if the other side tried to just withdraw the patent application to escape the fight. Second, Section 9 fixed a huge problem for co-owners. Before, you needed everyone to agree to make a change.
Now, a single co-owner could apply to amend or even revoke a patent, breaking that potential gridlock. And finally, Section 11 gave the comptroller's decision some real teeth by creating a clear path to enforce damage awards through the courts.
Now this is a really fascinating and fundamental shift in employee rights. Section 10 completely changed how you calculate compensation for inventors who are employees. Under the old rules, you looked at the benefit the company got from the patent itself, which could actually be quite limited. The 2004 Act blew that wide open. Now the calculation is based on the outstanding benefit that comes from the invention or the patent or both. You see, an invention could be a game changer for a company's process or reputation, even if the patent document doesn't earn a ton in licensing fees. This change makes sure the employee inventor gets a fair slice of that much bigger pie.
The Act also went after the problem of groundless threats, basically patent holders trying to bully people with the threat of a lawsuit. Section 12 created a new defense. Imagine a patent holder threatening a small shop owner for selling a product. Well, this new rule protects that shop owner if the patent holder can't prove they first used their best endeavors, meaning they tried everything reasonably possible to find and go after the real source of the infringement, like the manufacturer or the importer. It stops big players from intimidating the little guys down the supply chain.
So, we've talked about some massive legal shifts, but the Act also had this other really important focus, just making the patent system more practical and easier to use for everyone, from a lone inventor tinkering in their garage to small and medium-sized businesses. And the heart of this user-friendly approach was a brand new idea introduced in Section 13, the Patent Office Opinion Service. This basically allows anyone, whether you own the patent or you're a competitor, to get a formal expert opinion from a patent examiner on whether a patent is actually valid or if a certain product would infringe it. The two most important words here: low cost and non-binding.
In this question is exactly why the service was created. It's meant to be an affordable reality check. So instead of jumping straight into a crazy expensive court battle, you can get a kind of temperature check from an expert. This can help you figure out your business strategy. Maybe it pushes both sides to settle, or it could give you the confidence that, yeah, you've got a strong case and it's worth fighting for. It's just a brilliant tool for trying to solve disputes early.
The Act also bundled in a bunch of other important administrative tweaks. Section 15 gave the comptroller clearer power to order a party to provide security for costs, which is a way to discourage people from starting lawsuits they have no intention of finishing. Schedule 2 added a neat provision that lets inventors waive their right to be named on the patent, which is great for privacy or security reasons. And a simple change, but a smart one, aligned the comptroller's annual report with the financial year, just bringing it in line with standard government practice. All these little things added up to a much smoother system.
So, after going through all these nuts and bolts, what's the big picture? What's the real lasting impact of the Patents Act 2004?
When you step back and look at it all, the Patents Act 2004 was a massive success. It was a comprehensive and much-needed overhaul. It brought UK law in sync with its European partners. It brought real clarity to super complex areas like medicine. It rebalanced the rights of everyone involved in disputes, and it made the whole system more accessible. It was, without a doubt, the software update the UK's innovation engine needed to compete in the 21st century.
And that, of course, brings us to the never-ending challenge. The 2004 Act was a perfect response to the world as it was then. But technology, as we all know, never ever stands still. With fields like artificial intelligence and genetic engineering just exploding and blurring the lines of what an invention even is, it leaves us with one final big question. When is patent law going to need its next fundamental upgrade to keep up with our own ingenuity?